Still going up. I don't know whether to start or not. I think we'll make a start just because this could go on forever. But it's so good to see so many of you joining this webinar. Thank you all for sparing your time. This webinar is on copyright, and it's the last in our series covering advertising, brands, copyright and designs, our so-called ABCD of soft IP. It has been and continues to be a difficult time for everyone. So we're so grateful that you've chosen to give up some of your precious working day to spend it with us. We've been delighted with the engagement you've shown through the thoughtful questions you've asked, the number of you who've provided helpful feedback, and the number of follow-up queries you've contacted us about afterwards. It's been such a shame not to be able to see you in person as we normally would for our seminars, but every cloud has a silver lining, and I know that as a number of people who have found this webinar format very helpful, as it's meant you've been able to join when otherwise you might not have been able to. In fact, somebody has just commented to us that they've joined from Malaysia, so welcome to you. Copyright is something that many people have a conception about, but not many people really understand properly. Perceived to be the exclusive domain of writers, artists and musicians, many underestimate the value it can provide to companies more generally. We're increasingly finding that clients are not only becoming more aware of copyright, but they're using it to great effect. Sometimes copyright has been the deciding factor in our cases where other rights have perhaps fallen short. Copyright is useful for every business, sometimes in minor ways and sometimes in more important ways. But you won't know how it's useful until unless you understand its potential and plan ahead so that you're able to deploy it when you might need it. To help you make the most of your copyright, because you all have some, I'm very pleased to introduce you to Kami Salhan, a rising star in our team. Kami has the misfortune to do most of her work with me, from helping clients to understand how best to use their IP, to helping them to use that IP to prevent others from ripping them off. Kami's most recent case was the Freddie case that I talked about in our last webinar, and she also works for clients ranging from Aston Martin to Joseph to Unilever. One of Kami's key areas of focus for her practice is copyright, having advised on the implications of the European Copyright Directive and on the implications of recent case law on copyright protection for products. Therefore, I can think of no better person to introduce you to some of the key themes of copyright law in a practical, commercially relevant overview. Kami, no pressure, over to you.
Quite the introduction, John. So good morning, everyone. It's really great to be talking to you all today about copyright and what brand owners need to know about copyright. So I just want to take you through the things that we're going to be looking at over the next 45 minutes. So firstly, I just plan to discuss why we should use copyright, why brand owners should be thinking about copyright, and then how brand owners can use it. So first we'll look at the benefits and some of the common pitfalls, but then we'll move on to specific examples of how brand owners can use it as part of their brand enforcement arsenal, I guess. And then finally, I'm going to come on to look at some of the more recent developments in UK case law about copyright and design protection overlap. So that just gives you an idea of the sort of things that we're going to cover. So looking first at why use copyright. On this slide, I've just set out some brief bullet points about some of the benefits of copyright. So I think copyright is often overlooked by brand owners when it comes to thinking about protection of their brands in favour of some of the registered rights such as designs or trademarks, and even in favour of some of the unregistered rights like passing off. I think that trademarks and designs are really useful tools to have, but copyright has a number of benefits that can be very useful if you find yourself in a bind or when you discover that somebody is infringing your works. So just taking each of these in turn. Firstly, copyright in the UK is free. You don't have to pay to register it, so unlike a trademark or a registered design. And this is particularly useful if you're launching a new product, or if you're launching a new brand, or if you're launching a new sub-brand, you're trying out a new slogan or something. It just gives you the opportunity to see if that works and see whether you like it before you may then pay to register it as a trademark, or register a design for it. I do mention that with a caveat, and that is that it does vary from jurisdiction to jurisdiction. So I know, for example, in China and the US, you do have to pay to register it. So it is worth checking wherever you're thinking about using copyright. But in the UK, it's free. The second point is that in the UK and EU, copyright arises automatically on creation. So copyright it protects the expression of an original creation. So something must be fixed in some form. So when you have a creative idea, once that is expressed, once it's written down, once it's drawn, once it's put into clay, whatever it might be, once that is expressed, you automatically attract copyright protection, and there are no other real formalities to think about. Thirdly, copyright lasts for a really long time. For most of the works that I'll come on to talk about, it lasts for the duration of the creator's life plus a further 70 years. So for a right that's free and that you don't have to do anything to register, that's really beneficial. You've got some sustained, long-lasting protection for an original and creative work. I've said here that it's a flexible right, and I think that's because copyright can protect many different rights within a singular item. This is a bit of an old school reference, but if you take a CD, for example, and if you think about when you look at the cover of a CD, there will be some artwork on the front of it, whether that's a photograph or a drawing. And then you might open up the CD, and inside there's the booklet with all of the lyrics written down, and they'll be protected by another copyright. And then on the CD itself, you've got the composition and the arrangement of the music, and that's another copyright. And you might even have additional artwork on the front of the CD. So those different layers of rights within what might be perceived to be a single product can be really beneficial to target any infringers that are using your original creations. So I think that's one way in which it's flexible. And another thing is that copyright is constantly adapting to cover more recent developments and changes in technology. So you're thinking about software and databases and social media. Each of those attracts different copyright protection, and so I think that's just another way in which the right can be considered quite flexible. I'm going to come to talk about some of the more recent developments in relation to design protection later on, and I think that again will give a working example as to how copyright is quite a flexible work. And then finally, copyright has quite broad territorial scope. So if you are in a Berne Convention country, there is reciprocal protection. So it's much broader than say an EU registered right. And so they're just a couple of the benefits. Looking at some of the stuff that copyright protects, I've put a diagram there and just set out some of the things that copyright protects. So in the top left-hand corner, I've put LDMA works. That stands for literary, dramatic, musical, and artistic works. I'm going to come on to look at those specifically in a moment, but I just wanted to give you an idea of some of the other things that it protects so that you can see and consider what might be relevant to your business. It protects software, sound recordings, broadcasts, and films, and then also typographical arrangements. So that will cover the way that words are laid out on the page, and that's particularly important to newspapers and publishers. But it can also be relevant if you have a product brochure. So even though it sounds specific to a type of industry, it does have other applications as well. So it's all about thinking about how copyright can work for you. So looking more closely at the LDMA works, I've set out on this side the literary, dramatic, musical, and artistic works. So just taking each of those in turn, the literary works are any works that are written, spoken, or sung. It can cover tables or compilations, covers computer programs and databases. You move on to dramatic works, and they're works of action without words or music. So it's something that's capable of being performed like dance or mime. Musical works are works consisting of music. I realise that's a bit of a circular definition, but that is what the statute says. So forgive that. And it excludes the words that are spoken or sung or any actions performed, because they would either be covered by literary works or dramatic works. Instead, it covers things like the melody and the harmony and the rhythm within a piece. And then finally, looking at artistic works, this is probably one of the broader categories. You've got any graphic works, so paintings, drawings, diagrams, maps. You've also got things like sculptures and photographs. You've got collages, works of architecture, and also works of artistic craftsmanship. So looking at those categories, I realised that they all sound very artistic and creative. And if you're sat there thinking, well, how do these apply to me, because I don't work in a creative industry in the same way, I think it's worth bearing in mind that these are just how we classify copyright protected works. So we use these categories for clients who work in heavy industries such as construction, clients in the real estate business, toy manufacturers, consumer goods clients. So they really do apply to everybody. It's just the wording in the statute that we use to categorize the works, and it's about actually what each of those categories cover. So as I'll come on to explain, literary works will protect things such as slogans, and you may have artistic works in your product brochures or in some of the social media posts that you make. So it's just about extracting the works that you're trying to rely on and thinking about what copyright protection they attract, rather than thinking about it in a creative context first. So it's just changing that initial way that you think about it. So just before we move on to look at how brand owners can use copyright, I just wanted to set out some common pitfalls. And I think from my experience, the most common issue that we come across when we're dealing with copyright claims is a lack of evidence or gaps in evidence. So in order to be able to rely on copyright, brand owners need to be able to show that the work was fixed in some form. They need to show who created the work, when it was created, and if it was created under a commission, whether those rights were assigned, or that the owner who, or that the person who is using the copyright protected work has been authorized to use it, whether by license or assignment. I cannot recommend and stress the value of records enough. So it's really valuable to keep records in the first place, but also to make sure that they're kept up to date and that they're organized and stored in a useful and sensible way. If you haven't been doing that already, it's not a massive problem. It's not life or death. It's just something that can be adopted from going forward, or you can do things like go back and look at those core works that you do use, and think about, do you have everything in place? And I'll come on in a moment to explain what instances of where that has really come into its own, where that has benefited brand owners. So looking specifically at how brand owners can use copyright, here I've just set out a diagram to explain some of the ways in which copyright might be relevant to a brand owner. And I thought that the best way to do that would be to explain in relation to the idea of creating a new product. So in the first column, I've got creation of a new product, product A, and that there are many things that the brand owner or the business will do to market and sell that product. And each of those things that a brand owner might do will attract different copyright protection. So here I've just taken the packaging and slogans as two examples of that to show you how it might break down. So looking at the packaging first, you would have some literary works in the way that the instructions might be written on the back of it, or whether there are any slogans, and then you also will have artistic works for the design of any labels, or for any drawings or photographs that might appear on the packaging. And then looking at the slogans themselves, they will attract any literary copyright protection as well. And I think it's worth breaking it down into these elements so that you can see the different things that you can rely on. And also just to remind you of the benefit that each of these rights arises for free automatically on creation. So it's really beneficial to both startup businesses who are testing the waters, but also for existing brands with well-established product lines where they just want to see the market's reaction before they spend a lot of money registering trademarks. I appreciate that there are certain types of product where you will want to register trademarks straight away and have protection for that. But there's also instances where you will want to try it out. So taking a specific example of a case relating to a label, the design of a label. This case is about the Marmite case, and this was a case actually that we as firm acted on. And whilst it does involve a really well-known brand, the Marmite brand, it was a very unusual set of circumstances. So I'm just going to set out the background to the case so that you have an idea of what the facts surrounding the matter were. So in 2010, around the time of the general election, the British National Party created a political election broadcast. And this broadcast featured the leader of the British National Party sat at a desk giving a talk. And then in the top left-hand corner, they had a image of the Marmite jar. And then at the end of the broadcast, the Marmite jar became much larger and more prominent in the centre of the broadcast. And instead of the Marmite name, the BNP had replaced that with the slogan, "Love Britain, vote BNP." Unilever are the owners of the Marmite brand, and they didn't authorise the BNP's use of the Marmite jar or the logo or design for the label. So they sought an interim injunction to prevent the broadcast being shown on television. And Unilever claimed copyright protection, copyright infringement, trademark infringement, and passing off. The claim was very urgent. It was pulled together in a matter of hours. So it focused primarily on copyright infringement, but also had those other elements that I'll come on to talk about as well. So I think in these circumstances, trademarks would be the go-to for a brand owner. They would think, right, well, we own a trademark for Marmite. They're taking our, even for we own a trademark for the logo, and they would think they're using that. But because this case was so unusual, there were some specific hurdles that Unilever would have to overcome, and they realised that this would be a difficult case. So it would be very difficult to show, for example, that the Marmite logo label was being used in the course of trade, because it was a political election broadcast, and so it wasn't. They couldn't be said to be any sale or any advancement of trade, because the BNP weren't really seeking any donations or anything. In addition, it was very difficult to identify what goods and services the trademark was being used in relation to, because again, it was more of just a statement, more of just a broadcast, and there wasn't really any intent in relation to goods and services. And so that's where the copyright claim really came into its own. With copyright infringement, you have to establish that a substantial part of the original work has been taken. And when I say a substantial part, I don't mean qualitatively substantial, so a quantitatively substantial piece. So it doesn't have to be a lot of the work. It has to be a core part of the work. So it's all about the quality of what you're taking, So it's about how integral the part that has been taken is to the original work. And that's very often why you'll hear cases about 3 bars being used from a song, and how that amounts to copyright infringement. Even though it's just 3 bars of a song, it could still be an infringement. So here in the Marmite case, it was clear to see that the core part of the artistic copyright work in the label had been used by the BNP, and that really overcame some of the problems that trademark law would have presented. So just why I think that's relevant or interesting to you, I think even where you may consider that you are significantly well protected because you have trademarks and because you invest in those registered rights. I'm not in any way saying that they aren't valuable, but there are some gaps where they won't always work. And I think that this is a perfect example of where copyright can be used to fill the gap where there hasn't been any trade. And I realise that this is an unusual set of circumstances, but you could be dealing with charities, you could be dealing with government or regulatory bodies, you could be dealing with individuals posting on social media, and all of those things may be instances where there isn't trade, but there may well be copyright infringement. So you can't necessarily rely on a trademark, but you could think about using a copyright. And I think, again, this is another really useful case to show my point about having the evidence of ownership lined up, ready to go. As I said, this case was pulled together in a matter of hours. And so having all of that copyright ownership information in a pack ready to go really helped progress and move things along. And if Unilever hadn't had a lot of the evidence like that to hand, then it would have struggled perhaps to show that. So another case that I think is really interesting about packaging and a claim for copyright infringement in packaging is this Gstar Holdings and Aldi case. So Gstar Holdings is the corporate entity behind Charlotte Tilbury. So on the left-hand side with the claimant's designs, that's Charlotte Tilbury's product there, and that product was called the Film Star Bronze and Glow. And the design of the packaging was created by both Gstar's employees, but also by another design company. And then the design company had assigned the rights back to Gstar as well. So Charlotte, the corporate entity behind Charlotte Tilbury, held all of the intellectual property rights. The product on the right-hand side was sold by Aldi, and this is sold under the Lacura brand. It's quite difficult to see, but on the design for the powder, you have two words debossed into the powder. So you might be able to see that it says sculpt on one powder and highlight on another. And it's even more difficult to see it on the Aldi one, but it does say shape on one powder and glow on another. So Gstar brought a claim for copyright infringement of both the Starburst design and the powder design against Aldi. And then they sought summary judgment on the grounds that they didn't think Aldi had any real prospect of successfully defending the claim. So I think this is quite an unusual case, because I think when brand owners are thinking about the rights that they have, it's not their instinct to think that they would have copyright protection in a powder or in the design of the packaging for a makeup product. So in terms of the powder itself, the judge said that because Charlotte Tilbury was able to provide evidence of the sketch that was underlying the powder, that artistic copyright could subsist as an artistic work in the powder design, because they had the underlying sketches. It didn't matter that over time, as you use the powder, the design would become less visible. It was clear that it was there. One point that he made about the words was that although you couldn't have copyright protection in the words themselves, the idea of the words as part of the artistic design did form part of the copyright protected work. The judge found that both the Starburst design and the powder design were original, and that Aldi had taken a substantial part of that original work. And the similarities between the two products couldn't be put down to anything that was common in the industry, or nothing amounted to general ideas. So it was clear that Charlotte Tilbury had come up with a fixed idea, come up with a creative idea, they'd fixed it in in the form of sketches and designs for that product, and then they'd manufacture the product as well. And then the judge said that a lot of those ideas had appeared in the Aldi product. And so the reason that I thought it would be interesting to talk about this case is, again, because it shows the flexibility of copyright. I think a lot of brand owners, like I said, wouldn't necessarily think that copyright would subsist in the design of a makeup powder. And so I think it just shows that any instances where you've had genuine creative thought or genuine original design in a process, that copyright, that may attract copyright protection if it can go into one of the categories that I mentioned earlier, one of the LDMA categories. I also think this case is a really clever use of copyright. Many brand owners have struggled to bring claims against Aldi because they think about things like trademarks and passing off, and there is no deception or confusion for the consumer when they buy a product in Aldi, because they aren't selling, well, very rarely they're selling the same branded goods in the Aldi store. I know that's not always the case now because they have moved into selling some branded products, but historically they hadn't been selling any branded products in the store. And so that inability to show that the consumer was deceived or confused at the point when they were buying goods meant that brand owners have essentially been blocked from bringing claims against Aldi for trademark infringement and passing off. Whereas with copyright infringement, you don't have to show damage to your brand. You don't have to show that you've suffered a loss. You don't have to show that consumers are confused. You just have to show that you had an original work, that you own the work, and that a substantial part of that work has been used by the alleged infringer. So I just wanted to use that as an example to show you some of the benefits of copyright in practice for brand owners. And so just moving on to the last section, I wanted to talk about copyright and design protection overlap. So over the past year, there have been a couple of cases that have really pushed copyright and design law to the forefront of intellectual property lawyers' minds when considering how to protect their clients' brands. And these developments aren't based on new law necessarily. It's more just that they've really brought to the front of people's minds the tension between national legislation and EU legislation. And I think it's really interesting to talk about these cases because they potentially open some new doors or given brand owners some ideas of how they can use copyright when they're thinking about brand enforcement. So I just wanted to give a little bit of background before launching into the cases because the cases are quite complicated. So as you all know, protection for products is usually done through, in terms of intellectual property protection for products, it's usually done through a composite of design rights, whether that's registered or unregistered design rights, but also sometimes, if you're lucky, through trademarks. So I appreciate that they can be quite difficult to get hold of, trademarks. So the question is then, can you have copyright protection for products or works of applied art, as they've been known? So looking at our copyright categories of the LDMA works, any product will have to fall within probably the artistic category of works to attract copyright protection, because it's very unlikely that a product could fall into any of the other categories. Historically, there had been a number of statutory restrictions in place that limited whether works of applied art or products could attract copyright protection, but these have some of these have been repealed and fallen away, and also this new case law that I will come on to talk about has perhaps just opened the door a bit on how copyright might be used. So before we get on to thinking about whether a product can attract copyright protection, it's worth just having a little look at the way that copyright works in the UK compared to the EU. So as I've mentioned earlier on in this presentation, the UK operates what is known as a closed list approach to to copyright protection. You have your categories of work set out in the statute, and that includes your LVMA works. And a work has to fall into one of those categories in order to attract copyright protection. As I've mentioned, the best category for products is artistic works. And so we have to look at the options within the artistic works category to work out what can attract or what might work for a brand owner when thinking about copyright protection in their products. So the two main categories or subcategories that come to mind within artistic works are works of artistic craftsmanship and works of sculpture. But each of those works has their own limitations. So historically, works of artistic craftsmanship have had to have had a quality of craftsmanship about them. They must be aesthetically pleasing, and they must have been handmade or bespoke. There must be that, like I say, craftsmanship quality to them. Sculptures, on the other hand, must have been created for the purpose of being a sculpture. The courts have really flagged that they will pay close attention to the real meaning of the word when thinking about whether something is a sculpture or not, and whether it was intended to be enjoyed purely as a visual thing. In contrast, the EU sets a bar or operates an open list policy where the general requirement is, if your work is original, then it will attract copyright protection. So that creates a tension at the outset between having only originality as the requirement to attract copyright protection, and having something that goes a bit beyond that. So having sculpture as being something that is enjoyed purely as a visual thing, or having that level of craftsmanship for works of artistic craftsmanship on top of the requirement of originality. So that's the tension there. And so the case that I'm going to go on to talk about now actually is Kofamel. And Kofamel is a decision from the CJEU, and it looked exactly at this tension between the open and closed lists. So Gstar, the denim brand, brought a claim against Kofamel for copyright infringement in Portugal for the design of a hoodie and a pair of jeans. Gstar claimed that the jeans and the hoodie were their own intellectual creation, which is the standard for originality in copyright law, and that should therefore be protected by copyright. At first instance, Gstar was partially successful, but Kofamel appealed on 2 occasions, so the case was then eventually considered by the Portuguese Supreme Court. And the Portuguese Supreme Court noticed this tension between closed list policy and open list policy. And so the previous interpretations of EU case law had held that copyright had applied to works of applied art in the same way that it applied to literary or musical works. So it applied in the same way to products as it had to those creative industry works, let's describe them as, and that the only standard was that the work must have been the author's own intellectual creation. So in assessing this, the Portuguese Supreme Court referred 2 questions to the Court of Justice of the European Union, and they asked, does EU legislation prevent member states from granting copyright protection subject to any requirements other than originality? And secondly, does EU legislation allow member states to take account of other factors such as artistic character? So again, that's going back to the point that we were talking about with works of artistic craftsmanship, and whether there can be that other level of aesthetic appeal or additional requirements. And the CJEU said that works of applied art could be subject to both design right protection and copyright protection under the principle of accumulation. And this was because the protection offered by design rights pursued a different aim to the protection offered by copyright. And so there were different policy purposes behind copyright and design protection. They clearly said that the only qualification for something to be classed as a work was that it was original. So again, that takes away all of those additional requirements that have been set out in UK national law, where where you're thinking about, again, the aesthetic appeal and the craftsmanship and what the meaning of the word is. And so you're now thinking only about whether that work was original. And the CJEU said specifically you cannot have other requirements in order for a work to be afforded copyright protection. So clearly this is quite a divergence between EU law and UK national law. And I say that this wasn't something that was new or something that had only just been legislated on, but this was the first case that had really brought it to the front of people's minds, I think, in such a stark and clear way. So then the question was really about how the UK would interpret this EU case law, because up until a couple of weeks ago, we were required to think about EU case law as being part of, or as higher than, in some cases, the Supreme Court case law. So there was a UK case that looked specifically at this issue, but from a UK angle. And the case was between Response Clothing and Edinburgh Woolen Mill. So Response Clothing had supplied Edinburgh Woolen Mill with a top that had been made of a jacquard fabric. And this fabric had a wave design woven into the material. During the relationship between the two parties, Response Clothing had decided that they wanted to increase the price of the top, and Edinburgh Woolen Mill had said no. Instead, Edinburgh Woolen Mill sent a sample of the fabric to a manufacturer, and they created a new or similar wave design. Response claimed copyright infringement, and they said that copyright subsisted in the wave arrangement either as a graphic work or as a work of artistic craftsmanship. The judge didn't agree that you could have copyright as a graphic work in the design of the wave arrangement, but he did look more closely at whether it could be considered a work of artistic craftsmanship. So in making his decision, the judge first considered whether the weave pattern could be considered a work. And he set out two considerations. Firstly, is the work original in the sense of being the author's own intellectual creation? And secondly, is there an expression of the original subject matter, i.e. has it been recorded or fixed in some form? And so it's not just a mere idea. You've got to have something a bit more than just your musings on the matter. You've got to have it recorded in some way. If the article could satisfy both of these requirements, the judge held that it could be considered a work. The judge then went on to consider the tension between UK and EU case law regarding works of artistic craftsmanship. And he found that the wave pattern was both the author's own intellectual creation, but also that it possessed aesthetic appeal. And so he didn't have to make a ruling in this case on whether the weave design formed a work of artistic craftsmanship, because he found that it already crossed the threshold into what existed under UK case law. However, he did provide more general guidance on the issues of works of artistic craftsmanship, explaining that a work of artistic craftsmanship can now be made using a machine, and that the aesthetic appeal of a work can be the appeal to customers, and that a work is not precluded from attracting copyright protection simply because multiple copies are made. And these were all quite major divergences from the previous UK case law, which had said everything had to be handmade, it had to be kind of one-off bespoke pieces. So it's really looking at expanding the category of works of artistic craftsmanship. So I've just set out here some thoughts on what it could all mean. My first bullet point is this the end of the closed list of LDMA works? Will it open the floodgates for wider copyright protection for different types of works? Personally, I think it's highly unlikely. It's clear from the court's decision in Response Clothing that they're reluctant to move too far away from the statutory list, even when thinking about the works of artistic craftsmanship. They were already talking about aesthetic appeal. And so there is that reluctance to move away from it. So, but I do think that the courts will probably have to start diluting the definitions of what might be considered a work, in order to ensure that the works that are original can be afforded some level of protection. As I've said, the categories or the existing lists of works are part of national statutes. So for there to be a real change, the statute and legislation will have to be repealed. And I also think that with Brexit, it's unlikely that policymakers are going to want to be seen to be moving more towards an EU or continental way of thinking, rather than maintaining the UK or English lists of copyright protection. My second bullet point is about it being potentially good news for the brand owners of classic designs. If a company can show ownership of a classic design, i.e. show when it was created and who it was created by, and that the company owns the design, or the artistic work underlying the design, then it may be able to rely on copyright for those products. And this will be really beneficial to a lot of luxury brand owners as well. So designers of iconic handbags or jewelry or classic cars, they might be able to claim copyright protection in the artistic works underlying the cars or underlying the design of the cars, for example. Previously, they wouldn't have been able to rely on this copyright protection because multiple copies of the product would have been made. So of course, cars are made in factories and things like that. But if there is that level of skill and craftsmanship, there is no reason why some luxury goods couldn't fall into the categories where you're now attracting copyright protection. And I think, provided that you can show at all times that the design was original, that's the most important thing for at least crossing that first hurdle. I know that we've already seen some instances of this in places like Italy, where Ferrari had a successful case claiming copyright infringement in the design of the shape of one of their cars. But there's no reason necessarily why this should be limited to luxury goods industries either, given the requirements for the EU requirement is only that level of originality. There does seem to be a reluctance from UK courts to move away from the idea of that aesthetic value. So one of the ways that they might do this is that the definition of originality might become more restricted. It might become more stringent in order to offset the dilution of the categories. So we'll just have to see how that plays out. And finally, given that copyright lasts significantly longer than registered design right or unregistered design right, it just gives brand owners a new way of thinking about how to protect their products when dealing with copycats and infringers. So they're just some things to think about. It's all fairly new in terms of coming into practice, but it's one thing that we're certainly trying out for clients at the moment. So finally, just before I finish, I wanted to give you some takeaway points just to think about. Firstly, my main takeaway, I hope that you take away, is that copyright is useful and relevant to all businesses. It's not just creative industries. I know that there might well be a preconception about this, and with good reason, because creative industries do have to rely on copyright a lot, but it can apply to clients in all fields. If you create something original, if you create new material, you will have some level of copyright protection. My second takeaway point is, please keep records. If you haven't started this already, it's never too late to start adopting best policy and best practices. You can think you might already have started this at some point, and you might need to go back to it, or you might need to start entirely from afresh. And it's kind of giving your business a copyright health check. You can do this yourself. You can come to see us to talk about what kinds of copyright might subsist in your work, and what you might need to be plugging the gaps in the ownership or recording or documenting. And my advice on this is definitely do it at the time. Don't leave it until until say you've worked with an agency to develop a new advert for something. Don't leave it until after you've stopped working with them to get those records up to date and to get everything in place. It's much better to do it once you're whilst your working relationship with a business is good. And then finally, my last takeaway point is to keep your records up to date. Diarise every half year or so, just to keep an eye on things and do an audit, and just to check that all of the documents that you need are there, and just to keep on top of it, so that should you ever need to take urgent action against an infringer, you have everything lined up. So that's it from me. I hope it gives you a helpful overview of copyright and how it can be used by brand owners. I think we're going to have a few questions, so let me just end my slideshow.
Thank you, Kami. Well done. That's excellent and very interesting. We've had quite a few questions. We've gone along. I've tried to answer some of them as we've gone along. So I think if I've answered a question, you will see the answer in. Everybody should be able to see the answers. One of them was about the case links. What I've done is I've tried to find them all while Kami's been talking, and I've shared them, but we will circulate them all afterwards as well, because I may have missed some. And we've written a few articles on this topic as well, so we will share all that with you afterwards. A couple of other quick points before we go into questions. One is just to let you know that a recording of this and our previous webinars that I mentioned at the beginning will all be available on our website later, and we will share the links with you in our follow-up email. Another quick point before we move to questions is after this webinar, a feedback form should magically pop up on your screen. We are finding those really useful because they are telling us what people have enjoyed and what they haven't enjoyed about these, and the sorts of things that people would like to see us covering later. So if you could just let us know your thoughts in that, I'd be grateful. If you miss the link or miss it when it pops up, it will also be linked on the follow-up email as well. So thank you very much. Just some time for questions. They're flooding in, so thank you very much indeed. First one, Kami, is you've said the copyright is free in the UK, but does it cover the UK territory only? I appreciate that's quite a big question, but do you want to give a brief answer to that?
Yeah, so I think copyright, once it arises in the UK, it's not that it just covers copyright in the UK only. You will have reciprocal protection in other places, but it's about checking in each of those territories whether there are any additional formalities to protect your copyright in those locations. So taking China as a common example, I know that that's an important territory for a lot of brand owners. I know our team out there take a lot of time to register and make sure copyright is in place, copyright registrations are in place out there, so that it can be properly enforced. So I think depending on where you're thinking about, I think the best way to do it is to identify key territories and then to think about what formalities might need to be in place in those territories. I don't know if you've got anything else to add there, John.
No, I think that's spot on. I mean, I think if you're not sure, come and ask us, but actually copyright is one of the most international of the rights because it generates automatically. You will find that thanks to the international treaties, it is protected in a lot of the world. But as Kami says, there are areas in which you do have to register it before you can enforce it or things like that. So if in doubt, talk to us. But that's part of getting your ducks in a row. If there are particular jurisdictions that are important, check out whether it's just completely automatic or whether or not there's more you need to do. But in the UK and the EU, which we sadly have to describe as two separate jurisdictions now, they are all treated the same because the law is largely harmonised. Another question, Kami, you were talking at the very end of your presentation about the importance of records. How would you, I mean, a lot of the people on this webinar are not doing IP every day. They're general lawyers or even business people, and so they can't spend a lot of time worrying about copyright, but they want it, I imagine. I'm putting words in all of your mouths, apologies if I've got that wrong, but how would you recommend that people do that practically?
I think each business will have their own way of identifying a work or a project that has been going on. I'll create something as an example, but if you were working on a new product and then you subsequently instructed an agency to create an advert for that product, or to create a product brochure, or to create some marketing for your website, anything that you did with that agency, I would firstly be checking your agreements to make sure that you are having the copyright assigned back to you, so that you own the copyright. And then once you have that information, you also want to be collecting all of the sketches that you can, any development ideas, and really then saving them as preferably electronic files, because then they're easier to search and send. I would try and make them searchable if you can, in case you need to look for specific words. And then in terms of titling them and things like that, record the date that the file was created, record the person who created the file, so that you've got details of the owner, but also flag if it's confidential as well. If things are part of confidential information, please put that in the title, so that not everybody is having access to these things, and save them in secure places that are, in password protected folders if they're confidential. It's about really just protecting business interests. It's not even necessarily about the IP focus on it. It's about commercial business interests, and making sure that all of that is securely saved, and in a way that makes sense to the business as well. It's got to be something that you can go and find quickly and clearly, so that being organized and being on top of it at the start, it takes a little bit of time, but it can pay dividends when you have an urgent situation. I think that's my main point on that, really.
I think there's a point here that it's about setting up the right procedures, isn't it? It's about making sure that as things are designed, you are not having to worry about every work as it's created. It's having a system in place so that things are done automatically, or they should be done automatically, and investing that bit of time, and perhaps even talking to somebody like us about how best to do that system will pay dividends later. The two times that I think we have the most problems with copyright in terms of enforcing it are, one, when there's been a corporate transaction and nobody's cared enough about the records of individual works. It's not the same as, for example, a trademark certificate or something, which is easy to search. The copyright works are many and unidentifiable at the point of a corporate transaction, so people don't care enough about them. So spend more time on it at that stage. But if the system's in place, then that shouldn't be a problem. And the other time is when you've had third parties who've done design for you. The classic one is advertising agencies, but it could be your factories in China, it could be wherever. If they're creating some things for you, if you haven't had an assignment of those rights, going to them cap in hand when you really need them later may be a problem. We've had some examples of clients who their advertising agencies no longer work for our client, and actually they may have created the infringing one. That sort of thing can happen, and they're unlikely to assign you the rights at that stage to allow you to enforce them against them. So there are times when it's pretty obvious that you should have done it earlier, and it would have been an easy thing to do at the point of the pitch process for the new advertising agency, or just doing the contract with the provider. At that point, people will normally agree to assign copyright. They may ask for a bit more money in return for it, because it is something they get to keep, but it is something that is much easier to ask for when they still want your business than it is after the event. But there's simple things like that. There's just a few things like that if you just get it sorted at the beginning, it's much easier. So many questions. Right, next one. We will finish at 11, I promise. I just want to make sure we get through as many of these as possible. Very quickly, Kami, you mentioned flexibility of use in relation to social media. Yeah. Can you expand on that at all, relating to social media advertising campaigns, for example?
Yeah, so I think, again, it comes back to my layers of copyright idea, and the CD is just an example, but if you take a post on Instagram, or a video that you post on Facebook, there will be within that different layers of copyright protection. There'll be a sound recording, there may be a film, it may be that you've just posted an image, and each of those will attract different copyright protections. You do have to be careful on social media, because I can't remember off the top of my head about the different rules about ownership of the copyright works once they are shared online. I think maybe with Instagram there is an element of waiving your rights to, in terms of taking action against Instagram, or they may own part of it. So that's just background knowledge, I think. So it's definitely worth having a look at their terms of use when you're posting things. But it's about making sure that, I guess with social media, it's a bit, the idea of enforcing your copyright is slightly different, because you do want the content to be shared. You do want people to have access to it. It's just about whether the content is taken and then used in a way that you didn't want it to, be. So it's firstly identifying the different rights that subsist in any social media post, and then looking at how that's being shared, and then looking at whether it's being shared in a way you want it to be, and then taking action. I will say that we have had situations where we've had to contact Instagram, and there are forms to report infringement on there. That's something that we help with, but it's also something that you can do in-house as well. It's just a simple filling out of a form, and there's lots of boxes, and you submit your evidence of ownership. With copyright, it is more difficult, because you do have to evidence and submit documents proving that you own the work. So you will, again, it comes back to my point about records. Once you've got that in place, you can then upload that very quickly and deal with it very quickly. And I think Instagram, I'm using them as my most recent example, but I think that they have a policy of turning around complaints within about 72 hours. So they can be really efficient at taking down infringing posts, and also helping to protect your copyright as well. It's in their interests, because otherwise brands will stop using their platform. So that's my brief thoughts on social media, I guess.
Sorry, we've seen a lot of success, haven't we, with taking things down on social media. Not always. It's not. Sometimes they can play difficult games, but generally we have. One final point. We've had enough. Sorry, we're not going to get to all the questions, and we haven't got to your question. I'm sorry. We'll get in touch with you afterwards. But one quick answer to one question, which was what we think of WIPO Proof. For those of you who don't know, WIPO Proof is a service which effectively provides a digital date stamp for your works. There are lots of those sorts of services out there. I know that Acid operates a similar system, and there are various others. Some people even use the registered design system as a way of date stamping their works, because you can file them as registered designs, and the cost is about £2 a design, and then you get both systems as part of that. They're all good, but having internal record keeping that independently dates the documents is also possible. So, or uploading it to something like Google Drive or anything like that, something where there's an external date stamp on it is good. So anything like that, you'll need to know for your own systems whether or not that's something that's possible, because if you produce so many designs, it may not be possible to upload every last one to an external provider. I'm conscious of the time. We're going to leave it there. Thank you very much, Kami, for setting everything out so clearly, and more importantly, thank you to all of you for joining. We've had, I think, one of our highest attendances ever at one of our events, which we're delighted about. So thank you so much. Please don't forget the feedback form, and we'll look forward to seeing you, maybe even in person, later this year for our next series of webinars. Thank you very much.
Thanks so much.